Welcome to It's Time to Get Your You Know What Together. And today we're going to be talking about owning rental real estate. So without further ado, let me introduce to you Samantha Fitzgerald. Samantha is an attorney in Plantation. Remember, she's getting ready to move, so make note of that address. And her firm is 100% focused on estate planning and probate and trust administration. She's been practicing for over 20 years. She is a CPA and has her LLM in tax. Welcome, Samantha.
Thank you, Bianca. Hi, everybody. Welcome for coming.
Welcome. Thank you. And my name is Bianca Moreras. I'm going to be your host and moderator. I am a business development coach and consultant, and I work primarily in the legal industry with lawyers and law firms, helping to build their practice. I've been doing this for 37 years, and I love what I do. I'm passionate about taking attorneys and others in business to their next level. So without further ado, owning rental real estate property. Come on, Samantha, should I put my rental property in a corporation?
Definitely not. So property can go into a corporation without triggering tax, usually, not 100% of the time, but it does not come out without triggering tax. So I've seen many instances where somebody put property in a corporation a long, long time ago, and now it's significantly appreciated and they want to take it out for whatever reason. Circumstances change, lots of things happen. Um, and if they want to take it out or they want to change ownership, do some estate planning, bring the kids in or anything like that, taking it out of the corporation is going to trigger tax if it has appreciated in value.
Okay, well, staying with that same topic, is this S Corp any different?
Nope. The only difference there's lots of differences between an S Corp and a traditional C corporation. But one of the big differences is a C corporation has what's known as a double layer of tax. So the corporation itself pays tax on its net earnings. And then to distribute those earnings to the shareholders or the owners, they then pay a tax on that income. It's called a dividend. An S corporation is a little different where it doesn't have the double layer of tax. So the corporation itself doesn't pay tax, but when it distributes appreciated property or when it sells appreciated property, there is going to be income recognized by the owner or the shareholder. So you can't get property out of an S corporation tax-free if it's appreciated.
Okay. Well, I know there's also an LLC. So I've heard that you should put rental property in an LLC for liability protection. Is that true?
Yes and no. So if you're going to put your property into an entity, an LLC or a partnership, but LLCs are more common now. An LLC is definitely the way to go. You can, for the most part, put property in or out of an LLC without triggering any taxable gain on appreciated property. So that's definitely the type of entity to use. So I get this question a lot from my clients that have rental properties and they're doing their estate planning. Should I put it in an LLC? If they've already got it in an LLC, then we typically leave it there. But when they're asking me the question, should I put it in an LLC? Does it reduce my liability? Well, the answer is typically yes, it does reduce your liability, but the explanation is very complicated. It's a long explanation. It's not super complicated, but it sounds complicated to the client. So I'll try to simplify it as best I can. There's two ways you may become liable to a creditor. One is if you have rental property and somebody on the property gets hurt. So your tenant gets hurt, or there's somebody on top of the roof and they fall off. Somebody's walking by and they slip and they fall and they sue you. So when you have rental property, so you're, entrusting it in the care of some other person, a lot of what goes on the property is out of your control. So you're exposing yourself to whatever the tenant is doing on the property, which increases your potential liability for being sued for something related to the actual property. So when something like that happens, the person who is suing, well, who do they sue? They sue the owner of the property. So if the owner of the property is an LLC, that's who they're going to sue. They can't, hopefully can't, sue you personally and go after your personal assets. They have to sue the LLC, and therefore they are limited to whatever assets the LLC owns. So there's lots of exceptions to this, of course. So one big thing is piercing the corporate veil. So the LLC is like a corporation. It's like any entity. It's separate and apart from its owners unless you don't treat it that way. So I'm going to hold off on that because that's a kind of a longer explanation. So that's one way to be liable. Another way to be liable is if you just happen to get sued. Let's say you kill somebody in a car accident and you get sued. They're going to sue you and they're going to go after whatever assets you have that are available to pay creditors. So owning this property in an LLC is protected in two different ways. So it's protected from those tenants' liabilities. When somebody sues because something happened on the property, well, they can only go after the LLC and the assets in the LLC. The other liability, where you kill somebody in a car accident and they sue you personally and go after your assets, well, what are your assets? Well, this property, if it's properly in an LLC, then what you own is the interest in the LLC and not the underlying property. So this is where the analysis gets a bit complex for people to understand. So let's go back to the first instance. The tenant sues you, or the tenant's friend sues you, and your property's in an LLC. So piercing the corporate veil is a thing. So what that means is if you didn't dot your I's and cross your T's and follow all the rules, they're going to try to ignore the fact that the LLC exists, and they're still going to go after you personally. So in order to make sure that that doesn't happen, it's really important to follow the rules. And a lot of people have trouble doing this. So you have to treat the LLC as if it's a separate person in a sense. The property is not owned by you anymore. It's owned by this LLC, by this other thing. So you should have a separate bank account for the LLC. You should deposit all of your rental income into that bank account. You should pay all your rental expenses out of that bank account. Treat the LLC as if it's a person, separate and apart from everything else that you own. Nobody ever does their annual minutes, and that's probably something you can get away with, but you have to form the LLC with the Department of Corporations, the Division of Corporations, sorry. You have to form it. You have to renew it every year. Small expense, not big, but it is something that you have to do. So I see dissolved entities all the time because people don't keep up with that. Well, a dissolved entity is no good. People commingle their rents and their expenses, and they're paying them out of their personal account. You can't do that. You got to keep everything separate. If you have multiple properties, do you put them all in one LLC or do you put them in separate LLCs? Well, separate LLCs are best. Why? Because when the tenant sues you, they sue the LLC and they sue whatever's in that LLC. If you put 5 rental properties in one LLC, you're exposing every single property to the liabilities of the other property. So the best case scenario is to have a separate LLC for every property, to have separate bank accounts, to treat them all really as if they're separate companies in a sense. And that's a lot for somebody to do. You should have, a tax ID for each one. It's just a lot for people to keep up with and to do properly. And if you're not going to do it properly, then don't bother doing it because you have a false sense of protection. So as far as tax returns go, in a single owner LLC does not have to file tax returns. So for federal tax purposes, it doesn't even exist. It's as if you own the property directly. So that's kind of a benefit. It's one less thing that you have to do. But if you have 2 or more owners, then you are required to file tax returns, and an LLC return is a partnership tax return. So that might be another expense that you're incurring. You have to probably hire an accountant to prepare that, because you're not doing that on TurboTax. It's somewhat complicated type of return to file. Okay, so then jumping back to the other type of liability, where you kill somebody in a car accident and somebody sues you. Well, what are they going to get? They can't get your property because you don't own that anymore. You only own the interest in the LLC. It's called a membership interest. It's like owning stock, but it's a membership interest. So can they still get the property though? Can they take your LLC away? Well, that depends. That's also a little bit of a complicated analysis. Having more than one owner in the LLC is beneficial. Then they cannot take the LLC away. The best they can get is what's called a charging lien against the LLC, so that any profits that are distributed, they can attach. But they can't take the actual LLC, and therefore not the actual property. When there's only one owner, you have still protection, but a little less protection. So the analysis is, if the profits that are distributed will never satisfy the judgment that this creditor gets against you, then they can take the actual LLC away. If it's a rental property that's distributing income, because maybe there's no mortgage and it's flush in the income and it's making distributions, then you're probably okay. So yes, the long analysis down to the short answer is yes, an LLC does give you liability protection. If you're one of those people that can handle following the rules and doing everything properly. And it doesn't come without any cost though. There are things you have to do. There are procedures you have to follow, and there is a cost. There's a cost to forming the LLC. There's a cost to renewing it every year. You probably need a lawyer. There's definitely some costs involved. It's not just like, oh, let me throw it in the LLC and then I set it and forget it, and nobody can ever sue me. So that's a good chunk of the analysis. I'm sure there'll be more questions that we can elaborate on.
Yes, we actually have a question, and that was a lot. That was a mouthful. So, Samantha, does the advice you're giving change regarding commercial versus residential investment property?
It can, and it depends. So things that you have to think about with properties. So commercial, you're gonna have more exposure. So pretty much for sure, if you're buying commercial property and you're at that level of business sophistication, you should own that in an LLC. It's really a business. It's not just a residential rental property that you're kind of doing on the side. A commercial property is a business, and that should definitely be in an LLC. And usually that's what we see, although occasionally I'll come across a client that owns a commercial property and it's in their individual name. Or sometimes I see where they have their own business and then they bought a property that they're using in their business and they put it in a separate entity, and they're paying rent because they think they're getting some sort of deduction for that. When in fact, you have to pay sales tax on that rental income, and you're still reporting the rental income. So in many instances, there's no benefit at all to doing something like that. And why people set up those structures, I'm not really sure. They must not have gotten good advice. But so for the most part, commercial property you definitely want in an LLC. And residential real estate, you still have all the same issues we just discussed. So there's definitely a benefit to having it in there, but you have to do it properly. Otherwise, you've just lost your benefit and wasted your money and your time.
Okay, that was a great response to that. I hope we answered your question. What if you have a mortgage on the property?
So that gets complicated because you can't just transfer the property without getting the consent of the lender, because that would trigger the due on sale clause. And technically the lender could then accelerate the mortgage and you'd have to pay it all. Whether they do or not, is questionable. But they certainly can, and they may, because, an entity is separate and apart from you. So it's not, similar to, an estate planning document like a trust where it's really still you. You know, you're the creator, you're the owner, you're the beneficial owner. An entity is really different. You know, it's a legal, it's like it's considered like a person. It's a thing. It's a separate being from you. So I would never allow a client to transfer property into an LLC without getting consent from the lender, and they certainly may not allow it. Similar to the loan is the insurance cost. So insurance is almost always more expensive in when the property is owned by an entity as opposed to an individual person, and it can be considerably more expensive. So, you know, whenever I have somebody ask me this question, whenever they say, should I do it? I'm like, okay, here comes the long explanation of what they should do. Um, I say, you know, go talk to your insurance agent and get a quote first. And then, you know, let's decide, you know, whether it's worth it, if it's something that, you know, I think they can even handle. Um, because you may, you know, think you're getting all this liability protection, but you're paying all this extra money every year when maybe your liability risk is somewhat low. Just depends.
So keeping on that insurance issue, do you, if you're in an LLC, do you even need insurance?
Yes, you know, you certainly need insurance for the property itself, you know, if it's damaged or there's a hurricane, and um, you know, you don't want to be tied up in a lawsuit. Um, most for the most part, people just want to be compensated for their injuries. They don't want to sue you. They don't want to be, you know, dragged out through a litigation. Um, so insurance is certainly beneficial, but you have to, you know, weigh the cost of, do I spend the money on doing this LLC and then I forego insurance, or do I just get insurance and forego doing the LLC? Or do I do both? It depends on your, you know, your cash flow. But having insurance is always a good idea. There's lots of things that it covers, you know, that the LLC is not going to cover. The LLC is really just protecting you from the outside world, but it's certainly not protecting the property. Or compensating somebody who is, you know, legitimately injured. I mean, if the roofer falls off your roof because of something you did, and you know, now their kids have no parents and no income, well, it would be nice for them to get compensated as opposed to saying, well, not my fault, not my problem, you can't sue me, you know.
Oh gosh, we're getting into so many things here. Okay, so you were talking about the LLC. Can I just do a quick claim deed and put the property into an LLC, or do I need a lawyer to handle that situation?
So I blogged about this recently, deeds gone wrong. So first of all, people are always asking me, can't I just do a quick deed? Well, there's no such thing as a quick deed. It's a quit claim deed. And we don't do them here because they invalidate your title insurance. So nobody should ever do a quit claim deed unless there's a reason for doing so. And so there's different types of deeds. There's a warranty deed, a special warranty deed, and a quit claim deed. So quit claim deeds are typically what you see people doing on their own. I'm not sure I know any lawyers that actually do them. Maybe it depends on the circumstances. So what a quit claim deed does is it says, I give you whatever I have, title wise. And if I don't actually own anything, then you don't get anything, but I'm not making any representations of title whatsoever, right? So why would anybody want to take title with a quit claim deed? So typically you're doing this in related party transactions. Oftentimes, as I said, people are doing them on their own. You typically don't see many lawyers doing them. In our office, we only do warranty deeds. Special warranty deeds you're typically seeing from developers. That's really common, but we always do warranty deeds. We want the same representations of title that we had here to go over there. And we certainly don't want to invalidate anybody's existing title policy, especially when it's between related parties. Or some sort of estate planning transfer into an LLC. Deeds are probably one of the least inexpensive legal document for a lawyer to prepare. People, and it's one of the most expensive assets you'll probably ever own. Why people do their own deeds is mind blowing to me. Nobody should prepare their own deed. Almost every deed I see that was self-prepared is wrong, and it has dire consequences. Nobody should ever prepare a deed. You should always go to a lawyer to prepare a deed. They're not expensive. It's a few $100s. It so the answer is no. Always go to a lawyer.
So what can I do to protect myself if I don't put the property into an LLC?
Great question. So after I have this long conversation with my clients answering their question, should I put my property in an LLC? I said, and if you can't do all of that, if you can't follow all those rules, then go get yourself some insurance. Get an umbrella policy. So make sure that you're adequately insured. As we said before, the insurance covers all sorts of things on the property itself, not just your own personal liability, but it covers the property. It covers all sorts of things. I even had a crazy case once where the defendants, I was involved, I wasn't litigating, but I was involved in it. The defendants' homeowners policy covered a wrongful imprisonment. It was an old policy with a bizarre rider on it, but it worked out well for us. So insurance can be great. Get an umbrella policy. They're not that expensive depending on the nature of your assets and your liability and risk. And I'm always surprised at how many of my clients have never heard of an umbrella policy. So an umbrella policy is an extra policy, insurance policy that serves as like an umbrella that covers you above all of your lower lying, insurance policies. So if you have auto insurance up to 300,000, then the umbrella policy kicks in up to $1 million or $2 million. So you can easily get $1 million or $2 million of additional coverage that's not that expensive, that will cover you for probably most judgments against you. So if somebody dies and they sue you, they're the breadwinner of their family, and they sue you for $1 million judgment, you have insurance. So that's the easier way. Now, there's a cost to that as well, obviously. So they have to weigh the cost of both things, doing the LLCs, getting the umbrella policy, and seeing which one works better for their particular circumstances.
Okay, so let's switch gears a little bit here to probate. How do I avoid my rental property from going through probate?
Another great question. So if you own the property individually, in your individual name, no LLC, it's going to go through probate. If you own it jointly with somebody with right of survivorship, it will pass to that person first, and then it will go through probate into the survivor's estate. If you put your property into an LLC, the ownership in the LLC is going to go through probate. So whether you own the property or whether you own it in an LLC, that ownership interest should be put into a trust, into a revocable, most likely a revocable trust, so that it passes according to the terms of the trust and it doesn't go through probate. You may have, properties all over Florida. You may have rental properties outside of Florida. In every state that you own a property, it's going to go through a probate administration there. Now, that is a little different if it's in an LLC, because then you just own the LLC and it's just your membership interest. So you don't need a probate administration in the other state. But the better course of action is to just put your interest in general into a trust, so that it doesn't go through probate at all.
Awesome. And, in the same context, can you just add your kids to a deed so it avoids probate?
This is such a terrible idea that I see lots of people doing. They add their kids to their deeds, and of course they prepare them themselves, so it's completely messed up. Or they add them to their bank accounts. It's such a terrible idea. So you do this for convenience purposes, and what happens? So now your child owns this asset, owns a piece of this asset. When your child gets sued, your property's at risk. If your child has to file bankruptcy, your child's at risk. If your child is incapacitated and you want to sell this property or refinance the mortgage, you cannot unless your child happened to do their own power of attorney, which I doubt they did. If your child is disabled and needs to qualify for some sort of need-based government benefits such as Medicaid or SSI, now they're probably ineligible. There's so many reasons not to add your child to your property or your bank account, including what if you have a falling out with them? I've seen that happen before. I had a client, she had a traditional life estate deed, not even one that you could undo, like a ladybird deed. It was a real life estate deed, and she wanted to do some estate planning. And it's like, well, you have to get your daughter's consent and to sign this deed to transfer the property. And they weren't really speaking anymore. So bad idea for so many reasons. This is why we put durable powers of attorney in place so people can manage your affairs if you're incapacitated. This is why we transfer property and your assets into trust so that they don't go through probate process.
All right. Well, I think that the information we were given was just stupendous. And, we meet here every single month, but in the month of July, we're going to take a little break for that summer fun in the sun. And we'll come back again in August, the third Friday of every month going forward. If you have any questions, you can call the office at any time, and we'll be so happy to take your questions and your comments and also assist in any way possible. So all of you, I'm sure you all know how to reach out to Samantha, and we're so happy that you were here. Samantha, any last words?
Nope, I think we're good. Thanks everybody for coming, and have a wonderful weekend.